Thank you, Lascan Corley. I'd like to thank all deputies for their contributions throughout this, I think, very good debate, very extensive debate, very respectful debate, I think, to all of the positions that have been articulated. I have to say, Lascan Corley, that I didn't hear any attacks by any colleagues on the character of others taking a different view, as was suggested earlier on. I think that all of the contributions have been measured, and there's been a very good analysis of the bill, very good analysis of the constitutional context in which we're operating. And I think that the Dáil has done itself proud in that regard in terms of the level and nature and content of the debate. I don't think it could at all be suggested by anyone that this Oireachtas has failed to debate this issue or to consider all views. There's been at least 4 occasions that I can recall in the last year or so where this issue has been quite rightly debated on the floor of the Dáil. The Health Committee has also, of course, treated the issue as well on 2 lengthy occasions. So I think that the issue has been well ventilated. There's been a good quality debate, and I think it's important that there should be so. That's what we're expected to do in this chamber, and I think that is in fact what has been done. As has been indicated since the intention to legislate in this area was first published, the sole purpose of this bill is to make provision for procedural rights for a pregnant woman who believes she has a life-threatening condition, so that she can have certainty as to whether she requires or is entitled to this treatment or intervention. The purpose of the bill is not to confer new rights to termination of pregnancy, but to clarify existing rights. And if I may add to that, or to elaborate on that, to make existing rights actually available. There's little point in a constitutional right that can't be exercised in Lascan Corley. And it's arguable that that has been the position, that rights or a right has existed that was incapable of exercise. And what we're doing in this bill is setting out a procedure and a mechanism for the exercise of an existing constitutional right. And we do so within the parameters of the constitutional provisions that pertain, in particular those as interpreted by the Supreme Court in the X case in 1992, and in order to implement the judgment of the European Court of Human Rights in the A, B and C against Ireland case. Legislating with the X case is a serious and legally complex issue, but I do believe that this bill strikes a balance between providing an accessible procedure for establishing whether a pregnant woman might undergo a medical procedure which will end the life of the unborn, and ensuring that safeguards are put in place for the protection of the unborn where possible, or in the precise terms of Article 43(3), where practicable. I'd like to address some of the main issues that have been raised by deputies during the debate, Lascan Corley, although of course won't have an opportunity to address all of the issues that have been raised. One of the most common reasons for opposing this bill is the fact that it includes suicide as a ground for permitting termination of pregnancy. The reality is that these grounds are already included in our law in this area. In the course of the judgments in the X case in 1992, a majority of the members of the Supreme Court specifically recognised suicide as a lawful basis for permitting termination of pregnancy, if it were established as a matter of probability that there was a real and substantial risk to the life, as distinct from the health of the mother, that could only be averted by the termination of her pregnancy. This principle was upheld, as many colleagues have stated, in 2 subsequent referendums on the issue. I think that the debate has been very interesting and very informed in respect of what the role of the Oireachtas is and what our role here is. There's been much debate about whether the Oireachtas is obliged to legislate, the extent of that obligation, and so on. But I think that a number of speakers in particular, many speakers refer to this issue, but a number of speakers in particular, I think, hit the point very well and in a very astute manner. If I may refer, for example, I think Deputy Durkin, who spoke just a few minutes ago, addressed this issue as to the role and function of the Oireachtas vis-à-vis the role and function of the Supreme Court, and indeed the people, the ultimate arbiter, the people of Ireland, who own the Constitution, whose Constitution it is. The people passed and enacted their Constitution in 1937. They amended it in 1983. A question arose in 1992 as to the precise meaning of that amendment. The Supreme Court, doing its duty, set out what that amendment meant and what that provision, Article 43(3), actually meant. And that's the role of the Supreme Court, is to interpret the Constitution where there is doubt or where there's a question arising as to the precise meaning of the terms of the Constitution. And that's what the Supreme Court did. We don't do that. The Supreme Court does it. The government doesn't do it. The Parliament doesn't do it. Where there's an issue as to interpretation, as to the meaning of a provision in the Constitution, the Supreme Court does it. And that is what they did in 1992. Some people have raised the issue, well, why would that, or ask the question, and people often wonder, well, is that the end of the matter? Well, it's not entirely the end of the matter, because, of course, if there's an unhappiness with the interpretation set out by the Supreme Court, the people can be consulted again. So, put it at its simplest, we would say to the people, here's what you put in the Constitution in 1983, here's what the Supreme Court says it means. Do you want to revisit that? And here's a proposal to revisit it. Here's a proposal to reword the 1983 provision in a manner that might find your favour. And that proposal is put to the people, and the people are invited to vote for that change and for that amendment, as it were, an amendment to the previous amendment back in 1983. And that was done twice. Not once, but twice. Done in 1992, in the period shortly after the X case judgment, and was done again in 2002. And on neither occasion, Count Corley, did the people decide, in their wisdom, to exclude suicide as a ground for lawful termination of pregnancy in this jurisdiction. That was an opportunity afforded to the people to make that decision, and they declined to do so. So the position is that the court, having given its interpretation, the people having decided not to reverse what they decided in 1983, that, as so many people in this debate have said, is our law and remains our law. And there can be no doubt about that. There can be no doubt about that. Whatever other issues that we have to debate and disagree on, there cannot be any objection to the simple proposition that the Irish Constitution, the supreme and fundamental legal document of this state, allows for lawful termination to occur in circumstances including suicide. And as we've heard from many people in the course of this debate, and also in the evidence that was so often referred to here, that was given to the Health Committee, suicide in pregnancy is real. It is real. And I have to ask the question, I think we all need to ask this question, when the distinction is drawn so often between a physical threat and a threat that arises in respect of suicidality. I would ask a simple question. Does not the risk of death by suicide constitute a real risk to life? Almost crass to put it that way, in those terms, but it needs to be put in simple terms. If someone's life is at risk from suicide, well, that person's life is at risk. That is a risk. And I cannot understand how, although I respect those who have made the point, that they say in this House and elsewhere that they have no difficulty with Section 7 or 8, to the extent presumably that they accept that those sort of physical risks are real, but that they can't bring themselves to see that the risk that's being dealt with or being addressed in Section 9 is in some way a risk at all. I think that's a fundamental issue that people have not actually faced up to. So I think that given that we accept, if we do, that the risk of death through suicide constitutes a risk, I don't understand why there can be such, I don't understand why that people can feel that there is such a basis or such a rationale for having a different view of that risk than the view that they hold in respect of the other risk, which is to allow it, or to allow those circumstances to pertain in our law. And I do accept that it's rare. Absolutely I accept that it's rare. But it does happen. And when it does, it's always a tragedy. Many have, as I've said, argued against including suicide in the bill on the basis that termination of pregnancy is, quote, the phrase has come up so many times, not a treatment for suicide. And we heard from eminent psychiatrists during the Joint Oireachtas Committee on Health and Children who informed us, and it seems to be so, that there is no definitive treatment for suicide. So when it's constantly stated in this House, as it were, as an attack line on Section 9, that it doesn't stand up because suicide or abortion is never a treatment for suicide, I accept that abortion is not a treatment for suicide. The point here is, though, what we're doing in the bill is to legislate for that very, very small but real possibility that terminating a pregnancy is necessary to save the woman's life. And those circumstances, as I've said, include a risk of death through suicide, and must do. Deputy Michael McGrath, I thought, addressed this issue very carefully and very closely. And he finished off with a question, a rhetorical question, where he asked, I hope I'm not misquoting him or paraphrasing him, but I get the sense of what he said. He said, when he was talking about Section 9, he basically asked a question, was it ever the case that a termination was the only way to save a woman's life? I think that's almost precisely what he said. I don't think I'm being unfair to him in that regard. He left the question out there, rhetorically, to say, look, would it ever be necessary? Was it ever the case, that a termination was the only way to save the mother's life in circumstances of suicide? I think, with respect to Deputy McGrath, Count Corla, that the way we must pose that question as legislators is, are we saying that it would never arise? Are we saying, or is it to be said, or can it be concluded that it would never be so? That it would be, no, excuse me, Count Corla, this is the end of the debate, and I'm not going to be interrupted at all. I'm not going to be interrupted. And I ask for your protection. I ask for your protection, Count Corla. I proceed.
You've all had a say now because a long day and the minute.
The fact is that it ought never. I was talking about Deputy McGrath, by the way, not Deputy Matthews. That the way the question ought to be phrased, I think, if we're to be fair and reasonable in this debate, is: are we saying that it would never arise, or it could never arise? And I remember Master Ronan Mahony.
Sorry, on a point of order. What's your point of order, Deputy?
The point of order is this, Count Corla. You are not allowed ever to reframe a person's question that was reframed, that was framed a certain way. That's dishonest. You know that. If you
sorry, Deputy. You're on the point of order. Sorry.
It is.
Count Corla, what I said was, I fairly quoted Deputy McGrath, and then I simply said, in the course of the debate, as I'm entitled to do, that he put that question, and I'm saying I think the real question to put is the other one. That's a perfectly reasonable point to make in the course of the debate, and it's very hard to understand. It's very hard to understand why we're getting into interruptions now at the very end of the debate from a colleague. So the issue is, I think we know that it cannot be said that it would never arise. We simply cannot say that. And that is the basis upon which we have to proceed as legislators. There's another aspect of the debate that I have genuinely had difficulty understanding, and this is a genuine sort of objection that I have, because it's never really been properly explained to me. The notion that Section 9, if it's enacted, would have the effect of normalising suicide is the phrase that's used. Now, I genuinely cannot understand how that could be reasonably suggested that would follow. Where we have a provision in our law that everybody accepts as an entirely limited and restricted one, in circumstances where a woman finds that she is suicidal and seeks to have a termination and has to face the requirements that are set out in Section 9, the very rigorous requirements that are set out in Section 9, and that she is or is not certified as having a real and substantial risk to her life that can only be averted by termination. Those rare restricted circumstances, covered by a very rigorous process set out in the Act, that would have the effect of normalising suicide. I simply cannot understand that. The point has been made and it's been repeated, but it's never been explained. Now, I am aware, Ceann Comhairle, and the government is aware, that concerns have been raised on the question of gestational limits, the question of whether it could be possible to insert gestational limits on the carrying out of the medical procedures in the bill. I think it's important to stress in this regard that the proposed legislation only covers situations in which there is a real and substantial risk to the life as distinct from the health of a pregnant woman, which may only be averted by termination of pregnancy. To put the matter plainly, Ceann Comhairle, it will only allow a pregnancy to be terminated where it is judged that a woman may otherwise die. And when, for example, Deputy Tobin and others posit the circumstances of late-term pregnancies and the particular situations, to some extent I don't accuse Deputy Tobin of this, but elsewhere others have posited quite grotesque circumstances that might, in very rare, it might arise, which I think would almost certainly never arise, although of course there can be no certainty here. If they ever did arise, it would be very, very, very rare. And I have to say the Minister for Health was unfairly represented as having a particular view in this regard. And I think he and I are of the same view as all reasonable people would be in any analysis of this bill, that such circumstances would be extremely rare. But if they did arise in those rare circumstances, let us not forget what's also arisen in that circumstance, and that is a woman who may die if this procedure isn't afforded to her. And there's very little reference of that fact when that particular circumstance is being addressed. It should also be clarified that in such situations, while a woman has and we've made this point before, Ceann Comhairle, and I repeat it here again, that while a woman has a right to have the pregnancy brought to an end, the provisions in the bill are intended to ensure that in circumstances where the unborn may be potentially viable outside the womb, doctors must make all efforts to sustain its life after delivery. It's very important also to recall the definition of reasonable opinion. The requirements in 7, 8 and 9 require the doctors to give a reasonable opinion, and the reasonable opinion, as defined in the definition section of the bill in relation to a medical practitioner or a review committee, means an opinion formed by the practitioner or committee, as the case may be, in good faith, which has regard to the need to preserve unborn human life as far as practicable. The doctors must have regard to the need to preserve unborn life as far as practicable, which is exactly what the Constitution says. And I want to assure deputies, all deputies, that as currently drafted, the bill does prohibit the killing of a viable fetus. And including a reference to viability would not provide any further clarity in that respect, because different pregnancies become viable at different points in their development, and a clinical fetal assessment would still be required, as is the case now. So I come back to the point that the test, let's remember what the test is. The test is that there must be a real and substantial risk to the life of the mother that can only be averted by the procedure. And I know Deputy McConalogue raised this question as well, where he said, quite reasonably, he was pointing to other jurisdictions. He said, well, there are gestation limits in other jurisdictions, and quite liberal jurisdictions where the abortion law is quite liberal. But that's precisely the point. They are in jurisdictions where there's a liberal abortion regime. That's not going to happen here under this legislation. It doesn't arise here at all, in the notion that there's a liberal environment. We won't have a liberal environment in front of this legislation. Far from it. So we're not comparing like with like in those circumstances, I would respectfully say to Deputy McConalogue. Some deputies have expressed their concerns, Ceann Comhairle, about the potential criminalisation of pregnant women. I want to clarify that a woman can currently be prosecuted for an unlawful abortion under the Offences Against the Person Act 1861. And I quote, and this is an extraordinary provision still on our statute books. She, quote, if found guilty, shall be liable to be kept in penal servitude for life, unquote. This proposed legislation does not create a new offence for pregnant women. What it does is it brings the penalty for this offence in line with current parameters, in other words, not exceeding 14 years instead of life. And I certainly recognise that the potential criminalisation of a pregnant woman is an extremely difficult and sensitive matter, to put it at its mildest. But this provision reflects the state's constitutional obligations arising from Article 43(3), where it's the constitutional protection of the life of the unborn. And that is a very grave and important point here. To suggest that we could do anything other than have a criminal sanction associated with a breach, I think is not facing the reality of what the Constitution actually does. So just as I say we can't ignore the Supreme Court decision in the X case, I say that to colleagues who are opposed to this legislation, I also have to say, although I must say that I find it as a citizen quite extraordinary and frankly offensive, that the notion that there would be a criminal sanction associated or involved for a woman, for a pregnant woman in these circumstances. I also have to respect, and do profoundly respect, the Constitution. And the Constitution is clear on the right to life of the unborn and protection of the right to life of the unborn, and until such time as that's revisited, that remains the position. And if, insofar as there is there's a statutory provision restating the offence, I don't think there's any way of avoiding a criminal sanction of the level that is actually proposed in this legislation. And I do want to point out that the sentence to be applied in a particular case is always a matter for the court involved, and in the circumstances that we have here, prosecution may only be brought with the consent of the DPP. The bill clarifies existing law, Count Cole, as I've said. It doesn't address, and I'm conscious of what many people have raised here, it doesn't address many circumstances that arise very often, too often, for pregnant women throughout our country. For example, many colleagues would have liked to see other grounds being included in the legislation, particularly in the heartbreaking cases where there is a diagnosis of fatal fetal abnormality. However, again, these provisions, I have to say, with great regret, with profound regret, cannot be included here. Because the purpose of this bill is not to confer new rights to termination of pregnancy, but to clarify existing rights. The question to be clear about what people mean, or what people must mean, about separate representation for the unborn, and how it might possibly work, and what precisely is being suggested here. It isn't simply a case of the Attorney General appointing a lawyer just to act in some generalised way. Our system, Count Cole, is an adversarial system. And what is being proposed here, because it can only mean this, is to introduce some type of procedure allowing for a forensic cross-examination of a woman, essentially of her bona fides, in order to establish whether she's making an honest claim or not. What else could it mean? That's all it could mean. Article 43(3) neither requires nor contemplates such a procedure, Count Cole. The Constitution requires the state, quote, with due regard to the equal right to life of the mother, to respect and, as far as practicable by its laws, to defend and vindicate the right to life of the unborn. The state's obligation here, if you read the section closely, the state's obligation is to be carried through in its laws. The requirement on the state is to vindicate the right to life of the unborn in its laws. That's why the legislation before the Oireachtas this evening sets out a rigorous certification procedure by doctors, who are expressly required, as I've said, to have regard to the need to preserve unborn life as far as practicable. It would be wholly inappropriate and entirely unnecessary constitutionally to introduce a legal procedure with separate representation of the unborn. And frankly, Count Cole, there's no proposal that would be done in this legislation. Finally, some deputies have raised the issue, quite reasonably, of greater supports in relation to crisis pregnancy in general. I want to reiterate that the HSE Crisis Pregnancy Programme funds 15 service providers to provide counselling services in over 50 locations nationwide. A number of these services also provide access to free post-termination counselling and medical checkups. I would urge all women who have a termination of pregnancy to avail of these services, to which they are entitled and which are provided free of charge. To conclude, Count Cole, I would like to say again and reiterate that the main purpose of the Protection of Life During Pregnancy Bill 2013 is to restate the general prohibition on abortion in Ireland while regulating access to lawful termination of pregnancy in accordance with the X case and the judgment of the European Court of Human Rights in A, B and C. There's much talk about stepping stones and floodgates and the future and what the future will bring. I don't know what the future will bring on this issue. I do know, though, I agree with I think it was Deputy Kine, and in fact Deputy Walsh made the point, perhaps from a different perspective, but he made the point, many others have, that this issue will not be finally resolved in this legislation, because how could it? There's no country in the world that can put a final line in the sand, as it were, under this issue. It simply isn't a realistic proposition. Perhaps there'll be a future referendum. I think that the case for a referendum, a future referendum, will be made, and I think that it has some force. But I think the requirement on us in this particular context here with this legislation is to give legislative foundation to a right that already exists, a right that's in our Constitution. It's already in our Constitution. We're not putting it in there. It's already in there. We set out a procedure by which it can be availed of. And I think that it's a balanced piece of legislation. I think that it goes no further. I think it was Deputy Murphy, Catherine Murphy, who said that it was the bare minimum. And I think I have to agree with her on that. I think that's a fair assessment. Deputy Daly, on the other hand, I think suggested that we could have done a lot more, which I was surprised to hear her saying, because I think, in fairness to her, the legislation, the two different draft bills she brought forward, they made it very clear that what the constitutional constraints were. I'll just finish with two of the quotes from two colleagues, which I think fairly reflect on what's being done here. They're not particularly sort of legalistic in terms of what the two colleagues said, but I think that they encapsulate very fairly and in a very reasonable way what we're doing. Deputy McLellan described this measure as a matter of common decency, and Deputy Cowan described it as a good faith measure. And I thank both of those deputies for their support for the bill. I thank all of the deputies in the House who've set out their views, for contributing to the debate, whether for or against. I think that this legislation is measured, as I've said. I think it is fair-minded, I think it's balanced, and I would commend it to the House.
Thank you.